Welcome to Amaka Intellectual Factory, where I host podcasts and many other interesting stuff. 21 attorneys general fight race-based American Bar Association rule. I'm gonna be doing things a little differently here. I'm actually just gonna be reading the article. But before I do that, I want us to appreciate the gravity of the actions of these attorneys general. I want to point out the fact that it's attorneys general and not just mere attorneys that are pushing for this. So what's the difference between an attorney and an attorney general? An attorney is an attorney as you know it. That is a lawyer. An attorney general, on the other hand, is also an attorney or a lawyer. And then some. What's that some? The U.S. Attorney General, for instance, is nominated by the U.S. President and then appointed with the advice and consent of the U.S. Senate. Regular attorneys operate as state legislators under the direction of the Attorney General. That is the extra that the Attorney General is. Generally, at the state level, the role of a state Attorney General is to counsel state government agencies and legislatures and represent the public interest in their state. It is very important that I repeat this. The role of a state attorney general is to counsel state government agencies and legislatures and, quote and unquote, represent the public interests in their state. According to the U.S. race demographic statistics, Black people make up 13% of the population of the United States. With the depth of knowledge that I have, that is a whole nother conversation on its own. But let's just focus on the topic at hand. The United States has 50 states and then the District of Columbia. No matter how few the U.S. race demographic statistics says Blacks are in the U.S., I want to believe that all 50 states in the U.S. and the District of Columbia have some number of Black people. The history of the United States is incomplete without the history of the series of events that led to the civil rights movements and the eventual passing of affirmative action laws. The continuous racial bias and unprovoked aggression towards Black people in the United States by non-Blacks makes affirmative action much more relevant today. So a so-called attorney general whose role includes representing the interests of the public cannot claim to be anti-affirmative action because you automatically are discriminating against Black people. Ideally, this should be enough to disqualify any nominee to the office of Attorney General. It should also be criminalized and nipped in the bud immediately. Because if an Attorney General can claim to be anti-affirmative action, then anyone running for the office of the President of the United States might as well claim to also be anti-affirmative action. I hope that I have expressed myself with the least amount of legal jargons and in a manner a lay person would understand, because I feel like to further express myself would be repetitious and unnecessary. With all these being said, here is my reading of the article, where out of the 50 states in the United States, 21 attorneys general, not just mere attorneys, but attorneys general, are pushing for the removal of race-based affirmative action in American Bar Association rules. So here it goes. 21 attorneys general fight race-based American Bar Association rule. Story by John Stife. Tennessee is leading a 21-state fight to remove race-based criteria from the American Bar Association's accreditation process. The ABA is the accrediting body for law schools in the United States and has a current rule being considered for revision as the state attorneys general say it compels law schools to consider race in both the admissions and employment contexts. Tennessee Attorney General Jonathan Scimetti wrote a letter to the ABA's council signed by Alabama, Alaska, Arkansas, Florida, Georgia, Idaho, Indiana, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Montana, Nebraska, Oklahoma, South Carolina, South Dakota, Texas, Utah, and Virginia, asking for changes to the rule. The letter cites the Supreme Court ruling in Students for Fair Admissions versus President and Fellows of Harvard College, which does not allow for race-based discrimination in admissions. The rule of law cannot long survive if the organization that accredits legal education requires every American law school to ignore the Constitution and civil rights law, Scimetti said in a statement. The American Bar Association has long pursued the high calling of promoting respect for the law and the integrity of the legal profession. And we call on the organization to recommit to those ideals and ensure that its standards for law schools comport with federal law. The letter said that well-intentioned racial discrimination is looked at the same as malicious discrimination. If the standards continue to insist on treating students and faculty differently based on the color of their skin, they will burden every law school in America with punitive civil rights litigation, Scimetti said. And that's the end of the article. Like I said earlier, any additional thing I say now would be repetitious and unnecessary. May God deliver us from evil. Well, that's all I have to say for now. Until next time, take care of your lovely selves. And remember, life is beautiful and worth living.